The case for Section 3 is CAS and MPPL and another, 2022-12 MLJ 135. The plaintiff, P., a pilot, was in a relationship with the first defendant, D1, a stewardess at a Malaysian airline, since 2005. D1 is married to the second defendant, D2, a pilot for a Singapore airline. D1 and D2 got married on March 3, 2007, and had a daughter on June 23, 2008. P claimed he was the girl's biological father and had a relationship with D1 around August-October 2007. He said he provided financial support for the child until August 2014 and spent time with her until December 2013. In January 2014, D1 ended their relationship after discovering P's extramarital affairs. In November 2015, P filed a court order for a DNA test to determine the child's paternity. D1 denied P's claims, stating that she only spent time with D2 during the period in question and that the plaintiff was not the biological father. The first issue related to common law and equity is whether this court has the power to order a DNA test on the child to determine whether the plaintiff is the biological father of the child, and if so, should such an order to be made and to what is the extent of the court's role as parens patriae and whether its power is limited by statutory provisions and/or Section 3(1) CLA, which states that common law and equity rules apply only as long as they align with local circumstances. The High Court held that it has the inherent power under the parens patriae principle to order a DNA test to determine whether the plaintiff is the biological father of the child. This decision was based on the following findings. The plaintiff had established a prima facie case, proving on the balance of probabilities that he might be the biological father of the child. Evidence included his sexual relationship with the child's mother during the likely conception period, his involvement in the child's life, and his financial contributions to the child's maintenance. The presumption of legitimacy under Section 112 of the Evidence Act 1950 does not bar inquiries into paternity. The ratio decidendi can be split into three parts. First is the inherent jurisdiction and parens patriae. The court emphasized its role as parens patriae, which allows it to act in the best interest of children, particularly when statutory provisions are silent. This principle is derived from English common law, which remains applicable in Malaysia under Section 3(1) of the CLA, provided it is consistent with local circumstances. The second is the statutory presumptions versus paternity inquiries. The court noted that Section 112 of the Evidence Act establishes a presumption of legitimacy for children born during a valid marriage. However, this presumption does not preclude investigations into biological paternity. The court held that inquiries into paternity are permissible when supported by evidence and aligned with the child's welfare. Last is the best interests of the child. The court prioritized the child's welfare, affirming her right to know her biological origins. It acknowledged that a DNA test, with 99.96% accuracy, is the most reliable method for determining paternity and serves the best interest of the child. The case of Lim Hui Teek v. Li Lai Cheng, 2016, marked a pivotal moment in Malaysian legal history by distinguishing between legitimacy and paternity. It affirmed that inquiries into paternity are permissible under Malaysian law, delineating the breadth of judicial power under the parens patriae principle. In Stone World SDN BHD v. Ngare, 2020, the Malaysian Court of Appeal emphasized the court's inherent jurisdiction in areas where statutory provisions are silent, highlighting the judiciary's proactive stance in addressing legal gaps. In Babu Remialam Veal v. Vidya D/O Santhini Kalathine Padithadil Vidal, the High Court of Kerala differentiated between paternity and legitimacy to establish a child's legitimacy. Section 112 of the Evidence Act played a crucial role, serving as proof of the child's legitimacy from a genuine marriage, rebuttable only with evidence of non-cohabitation. Referencing English common law, the Malaysian court cited cases such as in Re L, an infant, 1968, and B. Br. v. B. J. 1968, which upheld the court's power to order blood or DNA tests in paternity disputes, prioritizing the child's best interests. The court ordered that within 7 days of receiving the order, the first and/or second defendant must bring child C to Hospital Tunku Aziza, formerly Kuala Lumpur Women and Children's Hospital. The hospital will then take necessary steps to collect DNA samples from child C and the plaintiff. This will be done through methods deemed appropriate by medical professionals to determine if the plaintiff is the biological father. If the DNA test results confirm that the plaintiff is indeed the biological father, several follow-up actions will be taken. Firstly, the court will issue a formal declaration recognizing the plaintiff as the biological father. Secondly, the plaintiff and the defendants need to appoint a qualified child psychologist within 21 days, or a mutually agreed extended period, to help reintroduce the plaintiff into child C's life and facilitate his access to her. If the parties are unable to agree on a child psychologist within the stipulated time, either party can seek the court's assistance to appoint a qualified professional. Additionally, the plaintiff has the liberty to apply for further orders regarding his access to child C and the method of paying maintenance for her, based on the child psychologist's guidance and advice. The court decided that there would be no order as to costs.
The dispute centers around the conveyance of land originally owned by Muhammad Ibrahim, who gifted the land as joint tenancy to his children. Before she passed away, there were problems with an incomplete transfer since one of the children, Aisha, sold off parts of the land on her own. After purchasing these sections, the plaintiffs filed a lawsuit demanding particular fulfillment of the contracts. The first issue is whether Islamic law, Mohammedan law, applies to the conveyance of the land gifted as a joint tenancy and whether the English common law principle of alienation re proprietaria crescendi applies to the severance of joint tenancy. The court held that Islamic law, Mohammedan law, did not apply to the conveyance of the land as it was unrelated to matters of marriage or intestacy, which are the primary domains governed by Islamic law. Instead, the conveyance was subject to the principles of English common law as codified under the applicable statutory provisions. The principle of alienation re proprietaria crescendi, which allows for the severance of joint tenancy, that was found to be inapplicable, as it was not embodied within the relevant statutory frameworks, including the National Land Code and the Civil Law Act 1956. The ratio decidendi for this issue is the Islamic law does not apply to the transfer of land as a joint tenancy, which is legal under English law. According to the National Land Code, such transfers of undivided shares are null and unlawful. Thus Aisha's unilateral sale did not end the joint tenancy. The court relied on precedents like Rehman bin Mihat, Dict, where settled property held in trust was found not to be subjected to Mohammedan law. For the overall judgment, the plaintiff's claims for specific performance were dismissed against the first defendant. However, the estate of Aisha was required to restore the benefit received from the plaintiffs under Section 66 of the Contracts Act 1950. In conclusion, doing this project allows us to learn how to read and assess cases, improving our knowledge in law. In conclusion,